You may have heard terms like separation of church and state or religious freedom. But what do those principles really mean? Although the term separation of church and state does not appear in the Constitution, the principle is laid out in the First Amendment. It guarantees freedoms concerning religion, expression, assembly, and the right to petition. It states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This means that government cannot make laws that favor any one religion above another, and that people are entitled to their own beliefs without government intervention. Protecting the freedom of religion doesn't mean people get to do whatever they want if they say it's part of their faith, however, but we'll talk more about that later. Throughout U.S. history, laws and policies have been adopted that reinforced and negated the principle of separation of church and state. Two simple examples of policies that go against the Establishment Clause are the addition of "under God" to the Pledge of Allegiance in 1954 and the official adoption of "In God We Trust" as the national motto in 1956. The 8th U.S. Circuit Court of Appeals has upheld the use of this language, stating that it is not coercive. It might seem harmless enough, but that language necessarily promotes a monotheistic ideal and doesn't take into consideration polytheists, atheists, or agnostics in the US. You might think, so what? It doesn't force people to be religious. Correct. But too many religious extremists use this kind of language as an excuse to push their theistic ideals into policy. Lawmakers and leaders with extreme religious views often cite the government's endorsement of a god to warrant things like Jim Crow laws, LGBTQ+ discrimination, healthcare denial, sectarian coercion, misogyny, child neglect and abuse, and many other major issues. They elevate religious practices above the law when those practices would otherwise be illegal. To try and navigate the tricky issue of creating laws without infringing on religious freedom, the Supreme Court created something called the Lemon Test, named after the 1971 court case Lemon v. Kurtzman. The test has 3 qualifications, each of which must be satisfied to consider a law involving religion constitutional. First, the law must have a secular legislative purpose. Second, the principle or primary effect of the statute must neither advance nor inhibit religion. Third, the statute must not result in an excessive government entanglement with religion. In a famous 1990 case called Employment Division of Oregon v. Smith, individuals consumed peyote, an illegal drug, as part of a Native American religious ritual, and were then fired from their jobs. The case worked its way through the justice system, ending up in the Supreme Court. Justice Antonin Scalia delivered the majority opinion, stating, "Democratic government must be preferred to a system in which each conscience is a law unto itself." Essentially, you need to follow the rules whether you're religious or not. A religious person has every right to hold whatever belief they want, but their conduct needs to fall in line with the laws that everyone else has to follow as well. Today, there are a number of laws and court cases that give people license to do things that secular organizations and individuals would never get away with. They only have to claim a deeply held religious belief. This kind of conduct is religious supremacy. This is not constitutional. This is toxic. For the good of our society, this has to stop.